So the issue we're going to talk about today is copyright and contract law. I want to hit both of them. I've done a bit of research. I've tried to brainstorm how these two areas affect you guys in here. So I'm going to have at it. I've got a bit of content to give you guys. If I'm missing something, if something isn't clicking with you, raise your hand. I'll call on you. I don't know everyone's name yet, but I will point to you and we can deal with it. If you got something more refined and personal you want to talk about, I'm happy to stay afterwards as long as people need. I'm going to start with copyright. First of all, what is, and I guess I'll say for my own piece, yes, I am a groom. Got engaged mid-January, and it's been fun because I have sat in front of many of your industry and have them talk to me about this venue contract and that catering contract. And I sit back and my mind kind of percolates about the legal ramifications of all of these deals. And I don't really share them with the people I'm talking to. I just kind of, go off in my own little world. So it's nice to be able to talk to people who actually care about what these things might be that I think about. I don't really share them with Melissa. She doesn't care either. So we'll start with copyright. Copyright is a legal protection, kind of a bundle of legal rights that we apply to artistic expression that is fixed on what we call a tangible medium, like a CD or a document. So you have artistic expression, protection on a medium. What is the protection? Well, let me back up. What is not covered in copyright? If we're talking about maybe the brand that you have for your company, that's not copyright, that's trademark. If we're talking about the secret sauce for your recipe, that's not copyright, that would be trade secret. If we're talking about your invention, that's patent law. So anything that's artistic expression, that's what we're talking about, copyright. Now, what are the rights that we affix to that expression? We affix the right to copy, to perform, to display, to distribute, to sell, things like that. So that means that if you are the owner, if you are the artist, for example, and you have this artistic expression, then you own the ability to sell it, to display it, to perform it, etc. That's your right. We call it like a bundle of sticks is the term that we all wide-eyed law school kids would learn 10 years ago. Bundle of sticks. Your bundle of sticks are all these rights that you have if you own the copyright. Now, since it's like a bundle of sticks, you could sell that. You could sell it to somebody else, and they could have it. And therefore, even though they aren't the artist, they're the copyright holder. So that's kind of the core group of work, of laws that we establish to protect artistic expression. Now, there are some exceptions, to that rule, but it would take far too long to tease them out here for you today. So instead, we'll just call it this bundle of sticks, these rights that you have. Now, because you have those rights, where it comes into play here is that someone else can't take your copywritten expression and, as you know, sell it, distribute it, perform it without your permission. You hold the key for where your artistic expression is going to be bought, sold, all of that. So in the event that you want to use someone else's artistic expression, you have to get permission. Well, I can think of two ways this affects the wedding industry. First, it could affect you if you are the person with the artistic expression. If you're the videographer, if you're the photographer, if you are the person creating that art, right, and you're putting it down on a tangible medium, you are protected under copyright law. There might be a glimmer in your mind, well, why don't I have to register that with the United States Library of Congress? You don't. Actually, the moment that you put that thing down on film or make a WAV file of it, it's copywritten, it's protected. Now, if you ever really want to assert your copyrights, yeah, you should probably go through the copyright registration process. But you still have that bundle of sticks by being the artist. Accordingly, someone can't use your work unless they get your permission. Well, if you're a wedding photographer, that means your bride and groom, technically, under the terms of the contract, or at least hopefully under the terms of the contract, they wouldn't be able to use their own wedding pictures for displaying them to friends or distributing them to family or setting them out in public. They couldn't do any of that without your permission. So you probably don't want to have, they probably wouldn't be terribly happy if that's how you treated them. We have to find ways to deal with that. Well, I've seen it work in a couple different ways. If you're the photographer, you take the photos, you own the rights. I've seen a lot of people in contracts say, I own these rights, but on full payment, I will sell them to you. And then at that point in time, you can do whatever you want with them. You can tear them up, you can print them, have a great time. But we now live in a viral world, right? What if you take that killer shot of the bride and groom on the motorbike, flying away down the road and the veil's going out, and some soda company comes along and says, that's a brilliant shot. I want to put that on the front of my bottle and pay a check to the bride and groom. You don't see any of that money. So that actually happened to my friend when I was a best man in his wedding 10 years ago. He, right before the wedding, hopped on his motorbike and Trisha got on the back, and it's a great shot, and it was on the cover of Jones' soda bottle. I don't know if they paid anything. If you were the photographer that took that photo, I'm sorry if you didn't get any money. But I'm pretty sure that if there was money paid, he or she would have wanted that money. So how can you work that in a contract? Well, first of all, get it in writing right up front when you engage your bride and your groom. And how I've seen it done the best is, listen, I own the copyrights, but on full payment, I give you an unlimited license to do whatever you want with these photos, except do something that will generate profit. And if you want to submit it for competitions or sell it to a magazine to publish, then just come talk to me. We'll put it in writing, and we'll figure that out. It's a very common sense way of dealing with copyright as the right holder. Fortunately, if you own the rights, then you are in control about how you give them out and how you want them to relate to you going forward. So you can kind of control that relationship. Where it gets harder, as I'm sure you know, is when you don't own the copyrights. And that is, unfortunately, frequently the case. I see it most frequently in the videographer world. Right? You're a videographer, you've been paid who knows how many thousands of dollars to record the event, to make this wonderful wedding video, and the bride and groom have a specific soundtrack that they want to throw into this event. They want Scream and Shout by will.i.am in the morning, and then they want Locked Out of Heaven by Bruno Mars when they're preparing, and they're going to want, for the wedding ceremony, Man, I Feel Like a Woman by Shania Twain, and the reception will be Gangsta's Paradise and by Coolio, and you're just the guy trying to put together the video, and now you have to put together a soundtrack. Unfortunately, you don't know Coolio. You don't even know his last name, probably. Shania isn't really around very much. Bruno Mars is on tour, but he's pretty inaccessible, so what do? Well, this is a really difficult problem, and the internet is abuzz with this problem because apparently some videographers have gotten sued very recently, and so there are a lot of videographers out there trying to figure out what are we supposed to do. Well, first of all, if they want that type of soundtrack, you should explain to them that copyright law protects the artistic expression that is fixed on a tangible medium. So therefore, by recording the song, Bruno Mars has protected himself. You can't use it unless you get Bruno's permission. Now, what we can do about that is, one, you could try and get a license. And for preparation for this, I went out and tried to get a license for Scream and Shout by will.i.am. I spent a couple hours at the computer, and I couldn't do it. Here's what happens. Artist records song. He takes his bundle of sticks that we talked about, those copyrights, and he gives them to a recording company. We'll say Universal Music Group. Recording company then turns around and sells the publishing rights, just one of those sticks, to the publishing company, which is typically a subsidiary. Publishing company then controls how that song is performed and licensed. So if you want a license for a tune like that, you got to figure out who is the publishing company for Bruno Mars, go to them, go to their website, and hopefully Google will help you figure out whether they are willing to help you license the tune. We are coming, into this modern age where recording companies are trying at long last to relate to the public. And so you can occasionally find a company that's willing to work with you, the small-time person. But until now, none of them are willing to work with you. More than that, music companies happen to love attorneys. And so if they find out about your video, they think, wow, I really love Gangsta's Paradise, and you owe me $30,000. So what we need to do is try and get a license. If your company, if your bride and groom are willing to pay you for the extra manpower to try and get a license, then go for it. But I would advise them that typically you're looking at a very expensive event. Even if you can get a hold of someone who will license it to you, it could be a several $1,000s event. However, that's not always the case, and it is worth an hour of your time to try and figure out if you can do it. However, if you don't go down the road to try and figure out Gangsta's Paradise, you could try a different route and go to a clearinghouse where music has already been pre-licensed. I've come in contact with a company that I think does great work. They're up in Seattle. They're called Audio Socket. And they go out and find music of every genre from Shania Twain to Coolio, that type of sound, and they put it in their online database. You can become a client for nothing, I think, and then browse through, or better yet, have the bride and groom browse through until they find the soundtrack that they want for their video or for whatever it is. And then they give it to you, they can get the license. It's a lot less money, and you get something. You get the assurance of knowing that everything is clear, you've got permission, you don't have to worry about a lawsuit.
And it's very user-friendly.
Yeah, super user-friendly. I mean, it's
no more need to
it's killer. They put a lot of money into their interface to make sure that people can use it quickly. So Audio Socket, I would recommend if you want to go that route. Another route, we are in Portland. We're in a DIY world, and there are infinite number of indie rock bands and solo artists who would love to have you use their music for free. So there's always that option. You could tell them to become hipsters, find music that they like, and put it in the video. Now, what if they don't want to do any of that? Sorry, let me just finish this one point. What if they don't want to do any of that, and they still want the video? What do? Do you lose the client? Do you say, I'm sorry, I'm not going to put Locked Out of Heaven in your video, and so you got to go? Just thinking from a practical perspective, I would never advise anyone here to run afoul of the copyright laws. However, I think about enforceability when I think about problems like this. Coolio is probably not going to see the bride and groom's wedding video. So he's probably going to be okay with what you're doing. He's never going to learn about it. There's never going to be an enforcement mechanism. So one thing that I would if I was the videographer, I would talk to my client and say, are you going to put this on YouTube? Is there any way that this thing could go viral? Because if you just want to show it to your friends, then maybe there's some wiggle room here if you just want to have it in your home. At least at that point, you know that it won't be enforced. Now, I wouldn't recommend anyone going down that road, but I think just in terms of practical enforceability, I don't see, if it's not going to go viral, it's not going to be enforced. That's just something to consider. Another mechanism that you should always use is when you're a videographer, I would pass along the responsibility for getting licenses to your client. If they are stubborn and insistent, we can put into that contract some language that says, hey, by the way, you, bride and groom, hereby agree that you are obtaining all of the licenses for all of this music, and should anyone come after me, you agree to indemnify me for legal fees, attorney's fees, costs, damages, you name it, till kingdom come, because I don't want to have anything to do with it. That would be a nice belt and suspenders way to do it. But long story short, I think the best way to go is to refer your clients to a clearinghouse where music has been pre-cleared. So was there a question about?
Yes.
Yeah, go ahead.
If a live musician plays Bruno Mars.
Great question. So this is where we get into another area, which would be the performance side. So everything I just talked to you about with regard to music, we call that sync licensing. Sync meaning that the audio is synced to the video. So it's a totally different world than performance rights. Another bundle of the stick, another stick of the bundle. The right to perform the music is similarly vested in the artist. So what does Bruno Mars do? What did Coolio do? They took that and they gave it to their recording company. The recording company took the stick out called performance right and gave it to a music performance society. And then that society can license that. The two big fish in this world are called BMI and ASCAP. They hold that right, and you can go to them potentially, and you may need to go to them to get a performance license in order to perform the music. Once again, this comes down to enforceability, right? I don't know of ASCAP going around suing people because guy with guitar played Lost in Your Eyes at the reception.
There was a kid at Saturday Market that got caught playing his acoustic guitar. Oh, they do.
Well, never run afoul of the copyright law. Moral of the story, write your own music if you're going to go to Saturday Market.
Jazzercise instructors have to pay ASCAP and BMI dues.
Sure, yeah. So if you're going to play music out there for people, then you're looking at having to license it that way. Again, this is something where you need to get permission. Sir?
Just very quickly, my lawyer told me that the majority of the bars and the locations that the musicians are performing have to pay ASCAP and BMI.
Hey, yeah, great point. So in the event that you are having a reception, for example, in a restaurant, it is worth checking with them if they have pre-cleared their music, their jukebox, because that would be a great way to go. If you're having a event in a private space, however, you're not going to have that luxury. Are there other copyright area questions, sir?
So if a venue that you play at has purchased rights through ASCAP, then it's okay?
Yes, you will want to check with them and determine that the licenses that they have obtained would cover the music that you want to play. They may have gotten the master license that allows them to do a lot more than allows them to do what you want to do, or maybe not. So you'd have to check that individually. Sure.
If a DJ or band actually has the license to play that music, on loudspeakers or perform it live, how does it work when you're recording that audio for a videography purpose on top of that?
So I forgot to give the caveat. First of all, I will repeat that question. And then I forgot the caveat that I don't know everything. This might be something that I don't know. But the question was, in the event that you have I keep getting distracted by this. If the musician has a license to perform, then does that translate into the videographer having a license to record and pare down with the video? Great question. And I don't know the answer off the top of my head. If you give me your card, I'm happy to research it and email you and let you know.
No, but in theory, again, it goes back to enforceability.
Mm-hmm.
Like, you're hired to record the event. It's playing in the open.
Yeah.
How can you not record?
Yeah, I think if you record it, then what you're doing is putting it down onto a medium for people to listen to later. As soon as you get into that world, you get into what we call the mechanical license world, which is different than the performance license world, right? So, just being by the book, my bet is no. But I'm sure that's been litigated somewhere in this nation, and I'd love to figure out the answer and let you know.
Really?
Yeah, sure.
So if I put together a video and I record some copyrighted music that's popular and I give it as a gift or I just show a friend of mine, that's legal, right?
Good question. If you record a video and just sync it with some music, or are you saying that you perform the music, record? Okay, you just sync it with music.
Coolio.
With Coolio, okay, we just find Coolio on the radio, we record it, because this is what we do these days. We record off the radio on mixtapes. We pair that with some video. And you just show it to a friend what's going on there. Again, I think that if you are performing, I don't know the answer to that question. I think if you're just showing it to a friend, then I think that only comes down to enforceability.
It's a for-profit is what they're trying to.
Yeah, I mean, the record company is always attracted to where the money is, right? That's where they're going to litigate. But if there's no profit, are they going to care? No, I don't think they are. This comes back to something that I glossed over in the beginning, which is called the fair use rule. There's a fair use exception that the law has, which states if you're doing something that we'll call de minimis, or kind of something that is below what the law should care about, then we're not going to care about it. That's one of the factors in the fair use law. I don't know if that fits within it. It seems to me, just by the book, that if you're taking music and you're syncing it with video, you need a sync license. However, no one's going to care unless you're doing it for profit. One thing that I know AudioSocket has done is forge a relationship with Vimeo, kind of the alternative YouTube, and in that you can throw your video of you skiing down the mountain like a bat out of hell, and you can throw it on Vimeo and then go to AudioSocket, find the tune that sounds like you skiing down the mountain like a bat out of hell, and pair the two of them and pay $2 or something. So just the fact that we are creating something like that in the market leads me to believe that you would need a sync license. Other questions before I turn to contract?
So it's venue-driven. It sounds to me like what you're saying, and correct me, is that really this is client-driven, since a venue is providing a space for a client to come in and do a list of whatever they choose to do. So I'm not hearing venue liability here unless we actually create and sell any of these line items.
So the question is, from the perspective of the venue, is there liability if there's performance in your space?
Of which we didn't.
You didn't sponsor, you just rented out the space.
We didn't create, we didn't, you know.
Yeah, if you're just the venue and someone comes in and
And
does whatever they do you need a license? I think, and again, this is something that I haven't researched, my bet is that this will turn upon whether or not it's a public or a private space. If it's a public space, then there is a performance going on in your space that is open to the public, and you should probably investigate the possibility of needing a license.
I understand that's a problem.
Yeah, if it's
Private thing.
if it's a totally private space, do you have any liability for what happens inside of it? If I were you, I would put it in the contract that says you hereby agree to indemnify us for any potential copyright violations. Because I don't know, but it's better to be covered than to litigate that and then have to litigate the copyright dispute.
You never know. I mean, the events can be very complicated, or they can be very simple.
Yeah.
You never know.
So yeah, I agree. It's very complicated, and it's definitely something you want in your contract.
It's in our corporate contract, and the reason it's there probably is because
Yeah.
we're asking them, or telling them through the contract that they
Yeah.
have to get used to that. So
I want to get to contracts because I know I have to talk about that too, but I'll get this question.
So,
Yeah.
the copyright portion, definitely the component that is mandatory is that it's recorded on some type of media. And my question being, so a chef can't have copyright of a food dish that they make, or a baker of a cake that they make? Is that
Great question. So can you copyright, this is the type of stuff I think about too. So can you copyright a cake or just something that's not fixed on a tangible medium? A couple things you could do to fix fix it on a tangible medium would be to record your recipe, right? So at that point, and then take a photo of the cake. So there are ways to try and get there, but no, just what you make a cake is the cake copywritten? No. I want to turn to contract law and just cover a couple things for you guys because I know that you don't have lawyers all the time. Can I get your question afterwards?
It was just related to his. It's like, can you copyright your logos or your website as well?
No. So logos and website, like I said at the beginning, is something that is really dealt with in trademark law. And I'm happy to come back sometime and talk to you about trademark law because it's very important, but it's not a copyright thing. When it comes to contracts, I know that you only get a lawyer in maybe once a year, so I just want to cover a few things. Everyone here should have a contract for your own services. Every time you engage a client, that contract should be written, should be documented, copied, give them a copy, make your own copy, PDF that copy, have 3 copies of every contract. If you don't have first of all, if you're writing your own contract, I implore all of you to get an attorney to look it over. It might take them an hour, might take them 4 hours, but it will be the best. It will be totally worth your $500. And if you're pulling it off the internet, even more so than if you're writing it yourself. Make sure you get a lawyer to look at it. What do you need to think about when you have a contract? There are just 2 things I want to hit for you. Number 1 is you want to make sure that your contract is documenting the deal as it is. The second thing that you want to do, hold on, I know it's important, it's in my notes. All right. We want to document the deal, and we want to keep you out of court. That's what we want to do with a contract. So documenting the deal is really important. As I have learned, only being engaged for like 60 days, the deal changes. It just does. I mean, I'm engaged for 180 days. I'm going to be engaged just for 6 months, and that's because it's like the bare minimum time, I think, to plan a good wedding, and not a day longer for it to get any more complicated. And these deals do, in fact, change. So when the deal goes haywire, guess where everyone's going to look? To your contract. Your lawyer is going to say, well, did you have a contract? What does it say? And if you contracted for A, B, and C, and you delivered on X, Y, and Z, then you're going to have a really hard time collecting that pretty big payment at the bottom of the page that you thought you were going to get. You're going to go to your lawyer, and you're going to say, well, I know we agreed to A, B, and C, but really, right about 2 months ago, the bride told me she wanted X, Y, and Z. And I'm like, well, did you put that in email? And she's like, no. And okay, well, we could litigate that, but it will cost you between $20,000 and $40,000 to figure out what you guys actually meant. And we're going to have to take the depositions of 3 or 4 or 5 witnesses to figure out if anyone witnessed this conversation, what they meant. And then we're going to put it all on as a dog and pony show in front of a 12-person jury. And hopefully they will agree that you really meant X, Y, and Z and not ABC, and that you delivered, and therefore the contract wasn't breached. Then they'll look at you and think like you are some dishonest lawyer out for their money. And then you say, I wish you'd just written it down, and then everyone walks away with their tail between their legs. I've seen it many times. So, encouraging you right now, document the deal. How do you do that? You put a clause in your contract that says, there may be changes to this agreement. Currently it's A, B, and C, but all changes will be written and approved by both parties. Then, when bride wants X, Y, and Z, you send them an email. It says, hey, bride, I know we agreed to A, B, and C, and you'll find that contract attached to this email. I understand now that you want X, Y, and Z. I'm happy to do that for this amount of money. Just shoot me an email back saying that you approve it. And then you print that thing out, and you staple it to the back of your contract, and just keep rolling on like that. And that way you get a good, well-documented trail that will document the deal.
So an email is binding?
I love emails.
Oh, yeah.
I love emails. They're not, they're not a signed contract, but ultimately when the contract goes awry, my job will be to determine, to prove to a judge exactly what you guys intended. That will be my job, and that is a big endeavor. So if there's an email saying, hey, judge, this is what we intended, I can waive that in court, and everything goes away. Unless there are competing emails. So be careful what you email. Now, let's get back to keeping you out of court. There are 2 ways that I can see a wedding deal going awry, right? The first idea is that they don't want to pay you. The second deal, and you did a great job, they simply don't want to pay you. How do you get through that and still not lose your shirt paying an attorney to just get paid? The second thing about keeping you out of court is, what if they hate you afterwards and they come after you for your children, right? So they just, Bride just feels like she got the shaft. Maybe the baker was sick making the cake.
It's called wedding wire.
Right, all right, so they come after you, file a lawsuit, and it goes crazy. How do we keep you out of court? I'll start with the non-payment issue. If they don't pay you, what should you be worried about? First of all, I'd put in the contract potentially a clause for attorney's fees. That way, if you say, hey, Jake, you didn't pay me, I know it's only at $1,200, but if I file a lawsuit, I can get an attorney to do it, and then your bill is going to become $2,000, and then it's going to become $3,000 unless you pay up. And that's a good way of keeping people honest so that they're aware that they just can't give you the shaft and you got no recourse in the law. That's one idea. Another idea, and this is something that I can't stress enough to small companies, get as much of the money as you can up front. Possession is like 90% of the law, and in a small dollar case, it is 99% of the law. Get as much money as you can up front. Other ways that you can stay out of court, I had a couple more. I'll get this under, this is kind of different, but another way to stay out of court is if they take your stuff and don't want to pay you. So they take the photos and they don't want to pay you, or let's say they take the photos and they want to make money on them without paying you. They want to, let's say you're a wedding coordinator, we have a few of those in here, I'm sure, and you introduce them to a variety of subcontractors. They want to go around you and not pay you. These are all wonderful ways that I'm sure brides would never do unless they were just really desperate. In that case, put in some language for what we call a permanent injunction. And what that says is, hey everybody, in the event that you decide to go around and try and cut me out and keep me from ever getting paid, I'm going to be able to go to court and say, hey judge, this can't happen. I'm going to waive this document, and then the judge is going to issue an order that will permanently enjoin you from dealing with any of my subcontractors or using the photo to try and get paid for something else. It's a great way to get in court. Let me just tell you, when you think litigation, you should think 12 months. If you have a dispute with someone, 12 months to try and get to trial. Just, you haven't even gotten a resolution. What if they appeal? 12 more months. So time is money, right? So if you can get a preliminary injunction term in your contract, that cuts it down immediately. You can pay a lawyer probably $1,000, $2,000 to draft up all the docs, go into court, get an injunction, and then you have it that day. That's a big deal. Again, possession is 9/10 of the law. This is a way to get possession. Now, let's talk about the flip side. What happens if they want your children, they are done with you. Whatever it was, they want to pierce the fiduciary shield of your company, take your house, and deport you out of Oregon. In this event, there are a couple great ways to protect yourself, keeping out of court. One, limitation of liability. It's beautiful. You can put a paragraph in your contract that says, I am limiting the value of this contract to whatever the value of any dispute to the price of this contract. So it's a $5,000 contract. Things might go crazy, we all know. In the event that they do and you want to come after me, we agree right now that no dispute is worth more than the value of this contract for you. That's a great way to go. Another great way to keep yourself out of court, if you're dealing with subcontractors, really important, put in an indemnification clause, right? If you got Jake the Flake, the musician, and Jake the Flake, the musician, just... Yeah. And he doesn't show up to a venue, bride gets really unhappy and wants to come after you, you put indemnification in language in the contract that says, in the event that you can't perform your services, then you're going to pay for all of my legal fees and any damages that I have to incur. Just another way to try and protect yourself. I think I'm pretty close to done. I wanted to take a few questions and just reiterate before I do. One more thing, as I've said before, possession is 90% of the law. When it comes to contracts, get your money up front, get some security, and get everything in writing. Sir?
What is the enforceability of an electronic signature?
I have never seen a case where it has been held unenforceable. I think there's going to come down to a bit of intent. Like if the guy who allegedly signed it says, I didn't sign it, that's been forged, or your technology is crafty, I never intended to sign this, that will be an issue for a court to decide whether or not it's enforceable. But if the court finds that you intended to agree, then you can do it. I mean, I submit documents all the time to the court and electronically sign. So if
Or they just type in their name?
I just type it in, yeah. At the same time, just FYI, anyone can type in a name. So you might as well, if you can get it signed in pen, get it signed in pen. Because at that point in time, if they object, you can go to a handwriting expert, pay them $1,000, and then you win.
We have fill-in form, and we still insist on a signature or something.
Yeah, insist on the signature if you can. Yeah. Was there a question over here that I missed one? Okay. Anything else? Yeah. No? Oh, look at you guys. You already know all your contracts. It's all easy. Yeah, sir.
So, not related to copyright, but sometimes clients like cross out things and initial out.
Great question. Yeah. People love to.
Oh, 2,500?
Yeah, we call it blue penciling, crossing out things in the contract and then just initialing by there. Ultimately, it would be great. Here's what I do as a litigator. If I come across a contract with all sorts of writing on it, then I need to find the original, and then I need to find their copy and see exactly when this stuff happened. Everything comes down to ambiguity. If there's an ambiguous term, then it's going to take a lot longer for the court to figure out what that ambiguity means. So if you can, modify the contract and get it re-signed. If they want to cross out stuff and initial it, great. If you're okay with those terms, redraft the contract and get it signed again. If you're not okay with those terms, then you need to document that and stop performing. Miss?
Thank you.
Yeah. You're welcome.
We have an active war clause on our contract. We had to use it once with 9/11. We had a classical guitarist booked, and they decided not to do the wedding, and we gave them their money back.
Yeah. Yeah.
And well, actually, they did the wedding, but they didn't want to do the music. They just didn't think it would be appropriate, and we said, fine, no problem.
Yeah, so the question was more of a comment about how an active war clause can actually help you get out of having to litigate a problem. We call them force majeure clauses in the law, and it's essentially if there's an act of war or an act of God, all of a sudden a tornado drops in the middle of your wedding, then you're just not liable. It's good language to have. Again, this is a type of standard language that a good lawyer will just throw into your contract. It's the type of stuff that you end up wishing you didn't have to have because your client will look at a 4-page document and say, really, 4 pages for a DJ? And you're like, I'm sorry, my lawyer told me that I need language. It says a tornado might drop in the middle of your wedding. And just try and explain it as best you can.
Blame it on the lawyer.
What?
Blame it on the lawyer.
Blame it on the lawyer, yeah. When in doubt, blame your attorney if you can. All right, I think I'm done up here. I'm very grateful for your time. You talk to a Chamber of Commerce meeting or something like that. They don't care. You guys care. Really appreciate it.